section 1A. An election of a member of parliament under that section is set aside where there is proof on a balance of probabilities that there was non-compliance with the provisions of the PEA relating to elections, and that non-compliance affected the result of the election substantially. My Lord, let me preface my arguments on this issue by making two legal points. The first one, my Lord, it is irrelevant to succeed, for the petitioner to succeed on this ground. It is irrelevant that the non-compliance or elements thereof are attributed to the winning candidate. It is not necessary, my Lord, for the petitioner to succeed on this ground that any elements of non-compliance are attributed to the winning candidate. What the law requires, my Lord, is proof of non-compliance, and whether that non-compliance affected the result of the election in a substantial manner. That is why you saw, my Lord, throughout all our evidence, body of evidence, did not attribute the elements of non-compliance to the winning candidate. It is irrelevant, it is not necessary. My Lord, that's the decision of the Court of Appeal in Mbaju Jackson versus Tembo Gideon Ujongo. My Lord, we have now shifted volume 2. Mbaju Jackson versus Tembo Gideon Ujongo and another. That decision, there is the first one on volume 2. That is page 469. It's the first case in volume 2 at page 469. But the actual holding is at page 501. The actual holding, my Lord, is at page 501. If I could just... The holding is at 501, page 501. It's just paragraph 93, my Lord, where their Lordship said that the law does not require that irregularities or unlawful actions be attributed to the successful candidate whose election is challenged. Section 61(1)(a), now 81(a) of the PEA requires the court to be satisfied with two things. First, that there was failure to conduct the election in accordance with the principles laid down in those provisions of the law, and second, that the non-compliance affected the result of the election in substantial manner. That's the first legal point. Secondly, Your Lordship, the second point I want to preface this argument with is that it is also irrelevant, and it is not a plea available to the winning candidate, in this case the first respondent, to say that the petitioner may also have committed acts of non-compliance. That plea is not available. It is not a defense, okay, to a charge, to a ground, to this ground, my Lord, for the first respondent to allege any sort of malpractices against the petitioner, as the first respondent tried to do so in paragraph 3 of his answer to the petition. My Lord, that point of law was also settled by the Court of Appeal in Ngomanjime versus the answer, first of all, yes. Paragraph 3, he attempted to allege that the petitioner committed some acts of malpractice. That is not open to him. It is not even a defense. So consideration of whatever the petitioner may have done is irrelevant to this ground, at least, my Lord. And I'm saying, my Lord, that that point was also settled in the Court of Appeal in Ngomanjime versus EC and Winvianyima. Ngomanjime versus EC and Winvianyima. The authority starts at page 512 in our second bundle, in our second volume. But the actual holding, my Lord, is at page 524. The authority starts at page 512, my Lord. but the actual holding is at page 554. We have highlighted a lot of the relevant part, which is the effect of what I'm saying. In summary, my lord, the lordships are saying the law is concerned with the winning candidate. There is no logic in pursuing the losing candidate. The law is not concerned with that. So it is irrelevant when we are arguing this ground that the petitioner may have, as I saw the counsel for the first respondent try to bring out at some part of the cross-examination. Now, my lord, in paragraph 7.3, that's at page 4 of our petition. The petitioner pleaded a number or several elements of non-compliance with the law. This is in the petition at page 4 of that petition. Several elements of non-compliance were pleaded there. I may not repeat them, my lord, because they are already in the petition. The summary may be, or it may suffice for me to say, that the complaint was about the holding of the election in an environment that's not free and fair, the non-counting of votes cast at these polling stations, the 14, my lord, the non-transmission of results, non-filling of the DR forms, the non-tallying of these results, non-delivery of the tamper-proof envelopes, and final declaration of a winning candidate without receiving all envelopes from the constituency, as is the command of the law. That was the substance, my lord, of the elements of non-compliance with the provisions of the law. My lord, in the petition, we specified the provisions of the law which were breached. What did the respondents do in their answer? First, my lord, of course, my lord, I could also probably mention that the petitioner gave evidence in support of those claims together with the agents. Now, in answer to the petition, let me begin with the first respondent. What does he say? In paragraph 4 of the answer to the petition, he says, yes, there was 0 return from those polling stations. My lord, that concession in paragraph 4 of the answer to the petition is repeated in paragraph 6 of the affidavit in support of the answer to the petition. When he was here for cross-examination, my lord, he told us that he had polling agents at all the 197 polling stations, and that none of them had come back to tell him that elections did not take place in these 14 polling stations. Pressed further with cross-examination, my lord, he admitted, 1, that there was non-counting of votes. He admitted, 2, that the other forms were not filled. He admitted from the look of the tally sheets that the results were not there. All of those elements of non-compliance were admitted while the first respondent was on the stand. Now, for the second respondent, paragraphs 10 and 11 of the answer to the petition, paragraphs 10 and 11 of the answer to the petition, and paragraphs 9 and 10 of the second respondent's answer to the petition admit a greater majority of those elements of non-compliance. Admit a greater majority of those elements of non-compliance. My lord will retreat and read those paragraphs. You will see what I'm saying. Further, my lord, the second respondent filed 5 other affidavits. When you gave them leave to do so, they filed 5 other affidavits of Ahawe Fiona, Peace Shogaliwe Mugabe, Kamsime Kuhemba, Tamale Simon Peter, and Kakaide Gabastas. All those affidavits were filed on the 5th of May by your leave. Now, my lord, the silver lining that cuts across all of these 5 affidavits, which are the evidence of the second respondent, is that 1, there was non-counting of the votes at these polling stations. 2, that as a result of violence, this counting was not completed, and therefore that no DR forms were filled at these polling stations. This was the evidence of the second respondent. And from that body of evidence, my Lord, starting from the petitioner, the concessions of the first respondent, the concessions of the second respondent, it is our submission that all elements of non-compliance that were pleaded by the petitioner were proved or have been proved. Why do I say, my Lord, that all these things we pleaded were non-compliance? I refer you briefly, my Lord, some of the decisions that have held that each one of those things that we pleaded is non-compliance. Maybe perhaps, my Lord, to tell you that non-compliance simply means that there's provision of the law which has not been complied with, as simple as that. If the law tells you count votes, you don't count them, that's non-compliance. Fill DRR forms, you don't fill them, non-compliance. Take all envelopes before you declare, you don't do so, non-compliance. That's simply what it means. And in the petition, we specified all of those sections that the second respondent did not comply with. They told him to do something else, he did something else. Now, my Lord, I codified some of the decisions in our bundle of authorities that have held that all of these various things that we pleaded and which we have stated have been proved are elements and amount non-compliance with the law. The first one, my Lord, is at page 543. 543 of our bundle of authorities. This is the case of Apollo Kantinti versus Stella Sebalu. The actual holding, your Lordship, is at page 566. Very small line down there. Your Lordship is telling you that if you don't tally, that's non-compliance. Yes, 566. That's where the small holding is at the end of the page. We have highlighted it. The second authority, my Lord, is Joika Furakabatsi versus Amifa Kawoya, Supreme Court. That one is on failure to prepare or fill DRR forms. The actual holding is at page 631 to 632. 631 to 632. 631 to 632 is where the actual holding is. There, in very few words, my Lord, their Lordships, the Supreme Court said DRR forms are mandatory. They are not a matter of form, they are a constitutional command by virtue of Article 86, 68 rather, 68, 2 and 4 of the Constitution. So they held their Lordship, the Supreme Court, in that matter, that DRR forms are not a matter of form. In fact, my Lord, the Lordships went as far as saying if you do not have a DRR form at the polling station, you cannot declare the result of the election, because that DRR form is the basis of the declaration. Next, my Lord, is the case of Acheng Sarah Opendi, same volume. Acheng Sarah Opendi and another versus Ocho Nyakecho. That decision, the holding is at page 678. Actual holding, my Lord, is at 678. There, my Lord, in that decision, as you go there, 15 DRR forms had been tampered with and did not end up at the carry center. The Lordship, their Lordship in the Court of Appeal said that the failure to transmit those DRR forms, as was in this matter, no DRR forms were transmitted, amounted to non-compliance. EC versus Moscow, just briefly take you through, my Lord, decisions which have held that all of these things we have pleaded constitute non-compliance. That's what I'm taking you through briefly, my Lord. It's at page 701, same volume, and 701. The actual holding, my Lord, the page I'm referring to is where the actual holding is, but of course the case starts at 686. 686. But the actual holding begins at page 701. Their Lordships were interpreting a section, my Lord, of the Law Governments Act that is pari materia with that of the PEA relating to postponement counting and tallying of results. They said the EC had that option to postpone counting of votes as in this matter, postpone voting as in this matter. They had those options under the PEA, they did not take them, and instead went ahead and declared a winner without those 14 polling stations. That is non-compliance. It was held in EC. My Lord, first of all, my Lord, if according to the evidence of their own witnesses, they are saying there was violence at these polling stations, and materials were destroyed, by the way, they say that as well. Now, they could have postponed the election to the next day. My Lord, that's section 12E of the Electoral Commission Act. 12E of the Electoral Commission Act. My Lord, I say 12(1)E. That is the section, my Lord, that there is. It says the Commission shall subject to and for purposes of carrying out its functions under Chapter 5 of the Constitution and this Act have the following powers. E, to take measures for ensuring that the entire electoral process is conducted under conditions of freedom and fairness. My Lord, the lordships in the Court of Appeal have said that is that's the section that permits them to cancel.
That's the section
that permits them to cancel. My Lord, I have not carried, but I'll bring it, my Lord. Then, my Lord, back to the PEA, Parliamentary Elections Act. Section 64 allowed them postpone polling of the PEA. 64(1), where polling at a polling station is interrupted by a riot or violence or any other event, the presiding officer shall adjourn the polling to the next day. Yes, for polling, my Lord. Then for...
So in this case, was there interruption of polling? Was there interruption of polling, or it was just counting?
It was counting and tallying, my Lord.
So the polling was interrupted?
The polling was interrupted, my Lord, as we
So
said.
there was no need for 64(1).
Then my Lord, section... Yes, then section 76, my Lord.
76?
Yes. Section 76, my Lord. Maybe it is more direct what you want, my Lord. It says where counting, tallying, or recounting of votes is interrupted by riot or violence or any other cause, the presiding officer or returning officer shall adjourn the counting, tallying, or recounting to the next day. Section 76, my Lord. So I'm saying, my Lord, they had these options and they did not take them. And that amounted to non-compliance in view of the decision of EC versus Moscow that I've just referred to. Moscow, EC versus Moscow, Jacob. EC versus Moscow, Jacob. The page.
The next
Yes, my Lord.
the next, it has to be the next one.
Yes, my Lord. The section I've just read. It says the next day. Yes, my Lord. 26(1). Of the authorities, 701. That's where the whole unit is. 701. What the lordships we are saying in Moscow is that they had that option of postpone counting, tallying to the next day. They did not take it. That amounted to non-compliance. My Lord, just two more in that area. Amurpol, the decision of Amurpol versus Okero John Baptist. The holding is at page 718, but the case begins at 706. 718 is where the holding is, but the actual holding is at, no, 706 is where it begins. The actual holding is at page 718. That one is about transmission of results. In that case, only one DRR form had not been transmitted. It had disappeared somewhere along the way and did not end up at the tally center. Their lordship say the non-transmission of that DRR form amounted to non-compliance. Lastly, my lord, on this issue is our plea, my lord, that the winning candidate was declared on provisional results without first receiving all envelopes from the constituency. I rely, my lord, on the decision of Betty Muzanira Bamkwatsia, Betty Muzanira Bamkwatsia versus Winfred Comhange. That decision is at holding is at page 751, but it starts at 744. Betty Muzanira Bamkwatsia versus Winfred Comhange. The actual holding is on page 751. And that's the volume, my lord, that we are dealing with. Yes, my lord. Absolutely, my lord. Because the law requires, my lord, that before you declare a winning candidate, you receive all envelopes, all PR forms from the constituencies. The only exception that their lordships have created in this decision of Bank Muzanira is if the results that have not come are officially cancelled. That was not the case. No, they were not. They were not cancelled. The returning officer simply proceeded to declare the winner without receiving all results from the constituency, my lord, as is the command of section. Let me begin with the law, my lord. Okay. Section 72 of the PEA, which their lordships in Muzanira were interpreting. You are interpreting in the former section 58. Now it is 72. 1. Now it is 72.1. It provides, my lord, that 72.1 says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates or their agents, or such of them as wish be present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all envelopes. Now, my lord, in Bamzania, they said, of course, you can begin tallying. Okay, if there is, and that's what's required for in the law. You can begin tallying, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my lord, they created is of the decision, my lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my lord.
can you look for that one? What makes the results provision?
If they're not complete, my lord, that's all. If a constituency has 197 polling stations and they have results of 170 polling stations, they are provisional.
It's not a case where they are, let's say, they have 10,000 votes, and after more application, the votes maybe 12,000. So in that case, we say it's the other 10,000, more results are carried, and the total votes cast are 12,000.
Even that, my lord.
That's why it's saying
even that, my lord.
10,000, but now more votes have been counted, now total votes cast is 12,000. But in this case, they never change.
Even that, my lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazette, the results were different. In Muzanida, the court of appeal has said that is unlawful for the returning officer, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it.
So you were saying in a brief that
so,
declaration, what was covered in your evidence?
My lord, I only put the final declaration where that which you are saying.
You don't have that in your papers.
No, my lord. The previous results are but that was not my point. The point was that because you do not have all 197 envelopes, DR forms. The only indication is that what you have declared are provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751, where I am. Just below the second highlighted part, there, my lord, you are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And the cancelling, my lord, is not by implication. We appreciate, my lord, after the second highlighted part, down there, after the second highlighted part, down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missed. So that's non-compliance, my lord. So the law commands the returning officer to only. They were not. No, my lord. My lord, you cannot miss something that doesn't exist. This was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Nyakechu, Saropeni. Results have been declared, the other forms have been filled along the way, the transmission. Then they disappear. The court of appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course, you can't do it by word of mouth. Okay, there is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancelled. Not at all.
If they were not there, what were they expecting?
What? Then the question, my lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The voting. To the next. And how, because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, they will give them that option, and they didn't take it. Now, however, which brings me to the second limb of this issue. which is the issue of substantiality. Now that my Lord, I have told you, and I've given you authority and evidence that there was non-compliance with the provisions of the law, the next issue is whether that non-compliance affected the result of the election in the substantial fashion. My Lord, I will begin with the decision of Elizabeth verses 7. We all know it's a message of 201. But where that excerpt is quoted is at page 818. But the case starts at 793. Bantalibu Isa Nalukoola versus Isi and Oronede, 2021. The excerpt I'm referring to of this message is captured there. Page 818. 818 of the second volume. My Lord is 818. That's where the holding is, but the case starts at 793. The case of Bantalibu Isa Nalukoola versus Isi and Oronede. Now, my Lord, permit me, my Lord, to refer to that excerpt. I will not read the whole of it, but towards the end, His Lordship was trying to explain what substantial effect means. He says, that means that to succeed, the petitioner does not have proof that the declared candidate would have lost. It is sufficient to prove that the winning majority would have been produced. Such reduction, however, would have to be as we put the victory. What does that mean, then, my Lord? It means that in this petition, we don't have to prove, my Lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my Lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner. That is what we have to prove. Okay. I will have established substantial effect, my Lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My Lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin.
Can you check the total? Can they use this 16,640 from the 16,640? Is that the number?
Yes, I didn't get your question, my Lord.
16,640?
Yes.
The number of total voters.
14 points. Yes, my Lord.
I want you all people there to check the total number by checking
the tally sheet?
No? Subtract.
So subtracting this from
by
the...
by looking at the attached the rows, the voters' rows.
Yes, my Lord.
The voters' rows.
Yes, my Lord.
Can they check that? Total add up all the 14 states.
Okay, they'll do that, my Lord, as we go. But you can also get...
Whether that's the figure.
Okay, my Lord. But you can also get it, my Lord, from the tally sheet. The data sheet gives you the number of registered voters per polling station and those who vote. If you look at the tally, it could be easier, my lord, but even that they can do from here. But you can easily get
Do that, I can do there.
okay. I'm obliged. Now, what I was saying, my lord, is that the margin between the winner and the first runner-up, who is the petitioner, is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, she probably also say this, my lord, when she was here for cross-examination, and Mr. Vaz took her on it quite a bit, the petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strong votes. And that evidence was not challenged, my lord. My lord, why I mentioned that point is because the case overturned of Kia Moses versus EC and Aliko Habad of 2021 turned on that point. But I refer to it, my lord, at page 954. It turned on that point. Okay, the appellant in that case said, these areas which have been excluded from voting are my strongholds. It was not challenged at the Court of Appeal, my lord. The case turned on that point. At page 954 of our bundle of authorities. Well, that's now volume 3, my lord. A turn of Kia Moses versus Aliko Habad. 954, yes, it begins at 9:33, but the holding is at 9:54. In fact, my lord, when she was here, somebody was saying, hey, those were strongholds, okay, have the votes, have them. She actually gave them the votes. So the fact that they were not, they were her strongholds was not impeached. Now, my lord, let me also give this text. Because might be confused. How do we get substantial effects? Because I saw that the first respondent trying to bring another formula when the courts have told us what. How do you get substantial effect? My lord, you do not use the number of people registered. Why, my lord? For example, in this matter, the results of 183 polling stations are ascertained and are known, and there is no path. So if you want to get whether those people who did not vote had substantial effect, you don't use that number vis-a-vis the total number of voters in the constituency. We are not concerned with people whose electoral choice we know. How do you get substantial effect? You get it by comparing the margin between the winner and the runner-up, who is the petitioner in this case, vis-a-vis the number of those people whose electoral choice we do not. Therefore, my lord, in this matter, we are comparing 16,640 vis-a-vis 8,881. That vis-a-vis 8,881, which is the margin, yes, between the first respondent and the petitioner. My lord, I am not getting that from my head, but from the decisions of the Court of Appeal, two of them. I'll take you back a little bit to the decision of EC versus Moscow, 2021. That's volume 2. That's volume 2, my lord, at page 702. Where is volume 2? Page 702. That is where what I'm saying is. EC versus Osu. Page 702.
What does that say?
Just purify my Lord. Maybe my Lord, as I look for that exact holding, I didn't appear to have highlighted it. Let me begin with the Acheng Saro Pendi at page 680. Page 680. In how we get the substantiality effect. Page 680. Acheng Saro Pendi and another versus. Open, my Lord, starts at just a minute. Starts at 664. But the holding about this issue, my Lord, is at page 608. I have highlighted it. My Lord, the point is this. If you look at what we highlighted, what I'm saying is, when you are getting substantiality, you do not take into account the number of registered voters in the whole constituency. So the court said this, my Lord. The land judge should have considered the total number of voters in those 15 polling stations. Here the issue was about 15. In those 15 polling stations, which was 7,000, that number, as compared to the winning margin of 7,600 without the same polling stations. My Lord, page 680, we have highlighted that small part here. Page 680. So that's how we get substantiality. My Lord, back to Mosupo. Back to Moscow at page 702. 702. Back to Moscow at 702, my Lord. It's paragraph, I think, 445. The one that has 445 at the left-hand side. It's not highlighted, but it says the court was trying to find out, my Lord, what the number of the registered vote, what the number of those who had not been counted was, in order that they could compare with the number. Now, my Lord, let me underscore what I'm saying. Okay. If they can. Now, my Lord, let me underscore something as I get away from that point. And it's critical, my Lord. That's why I'm going around and about it a number of times. The first respondent theory is that if you want to know whether the election was affected substantially, you look at the small number of 16,440 vis-a-vis the number of registered voters in the constituency. I am saying that is a wrong test. And I've given you the reason, my Lord. You do not, in that test, take into account the number of people whose electoral choice has been ascertained. In this matter, my lord, the electoral choice that was not ascertained was only to do with 14 polling stations, whose total number of registered voters is 16,604. When we are looking for substantiality, it is that number, because it is those that we do not know how they voted, vis-a-vis the margin. If we find that those whose electoral choice we do not know is greater than the margin, then the election is put in doubt. Why? Because we do not know who would have voted what, at which polling station, what voter turnout. The mere fact that is greater, therefore, has the capacity to change the result of the election. Not change it for the winner to lose. Not change it for the loser to win, but as to put the election in doubt. That has been understood very critically. Now let me take you, your lordship, how the courts have applied this test standard. The Court of Appeal, how it has applied it, what exactly I am saying. I'll begin with Apollo continuity. Yes. I'll begin, my lord, with Apollo continuity. In volume 2, my lord, the holding that I want is at page 573. 573. What was the problem in that case, my lord? The problem was that results from 9 polling stations were not included in the final tally. Results from 9 polling stations were not included in the final tally. My lord, I was guiding that is at page 573 of the second volume. We have read the fact continuity, but we can just go back now for this point. 573. We have highlighted the lordship. Their results from 9 polling stations with over 5,000 voters had not been included in the final tally. The margin from the delegate results was as low as 326 votes. Their lordships had this to say, my lord. In our view, in view of our finding above that the 9 polling stations had not been included, we do agree with the land trial judge that the outcome of the results of the whole Chadondo East constituency was left in doubt. The non-compliance, therefore, affected the outcome in a substantial manner, and the trial judge was justified in annulling the election on that ground. See, my lord, their lordships are not touching voters whose electoral choice is no. No. Only the 5,000 vis-a-vis the winning margin. And because the number of 5,000 was far greater than the winning margin, the lordships held that the election was affected in substantial. I'll go to the next one, where this was applied as well. Wakaino Msokensere. Wakaino Msokensere, my lord, the case begins at 831, but the holding is at 870. I think we are in the second volume, page 831, but the holding is at 870. I think it's something that had in that matter. And he lost this very point. Yes, but the holding is at 870. 870 is where the holding is. I was just reminding Mr. Willis that he lost this point in that case. There are your lordships at page 870. They said, we agree with the trial judge that the total number of 17,239 registered voters in the 24 affected polling stations whose results were cancelled affected the outcome of the result a substantial manner. Again, only those whose electoral choice was not considered, not total number of voters. Permit me, my Lord, again to take you to Betty Bamzanira Mkwasya. My Lord, permit me to take you back to Betty Bamzanira Mkwasya at page 755. The authority begins at Betty Bamzanira Mkwasya versus Winfred Komaji. The authority begins at 744, but the actual holding is at 755. There, my Lord says the decision applies to this case after quoting Kanti Apollo, which I have just referred to. They say the decision applies to this case. The returning officer neglected to tally a substantial number of votes totaling 5,413, and he disregarded the same in his declaration of the elected candidate. Certainly went the route of the electoral exercise. It amounted to disenfranchisement. The voters' votes were not considered in the declaration of the winner. Then down there it says, consequently, the disenfranchisement of those voters substantially affected the outcome of the election, since the results declared contained in the return form indicated a much lower margin of 4,000. Then Muhindo Rehema, my Lord. Muhindo Rehema versus Wilfred Kiza, page 890. We are in volume 3, I think, my Lord. Page, the first authority on page 3. Volume 3, yes. The holdings are page 890, my Lord. There, my Lord, 13,426 had not been considered. That first paragraph on top, my Lord. And the Lordship said that was significant to affect the result of the election and substantial. Now, let me also say some of these legal points, my Lord. The first one, when we are determining substantiality, my Lord, the number of polling stations that the winning candidate has won vis-a-vis those of the losing candidate is irrelevant. As we saw, my Lord, from the theory of the first respondent, he attempted to tell us that, look, I have won in so many. I would have won in those others. Before I get to that, the number of polling stations that you have won is irrelevant. My Lord, I take you back to Mbaju Jackson at page 501. This is the second volume. Mbaju Jackson versus Temple Vision Mutungu, page 501 of volume 2 of our bundle of authorities. The actual holding is at 501. That case is the first one in volume 2. Paragraph 92. The Lordships in the Court of Appeal say it is true that neither the applicant nor the respondent number 2 won at any of the disputed polling stations. Just like here, we don't know who won. However, this cannot lead to the conclusion that such malpractices did not affect the result in a substantial manner. The election is won by the total number of votes cast and not by the number of polling stations at which the candidate wins. So that issue should be out of the way. It should not disturb your analysis. Secondly, my Lord, the other point I wanted to emphasize on this issue as I walk away from it. It is irrelevant It is theorization for the first respondent to say that because I won in the majority of the polling stations, I would have won even in those polling stations. And therefore, because he's saying that to say, my lord, that therefore the election was not or could not have been affected substantially. That theorization, my lord, when he came here in his answer and examination and began talking about trajectories, patterns, and those kinds of things, my lord, I'm saying that is without legal basis. For you to say, my lord, that because I won there, I could have won there, that guesswork, as I called it, my lord, as a reason for saying that the election could not be affected substantially, is without legal basis. Adding the number of votes and subdividing, as Mr. Mbabas took my client through, is without legal basis. It's guesswork. And my lord, of course, it is not lawful that courts do not act on guesswork. They act on real evidence. For that, my lord, I've given you the decision of Okare versus R in our third volume, I think. Yes, our third volume. Okare versus R. The page where the holding is 898. Okare versus R. It starts at 896, but the holding is at 898. There, my lord, the court was simply saying that courts do not act on fanciful theories. They act on real evidence. And so if the reason, my lord, from the reading of the answer to the petition, the reading of the affidavit, now if you follow the cross-examination of Mr. Mbabazi, the theory was simple from the first respondent. In the third one?
I don't just for control. We don't have 898, the one being quoted.
You have
Our copy has 891. From there it goes to 916.
That's it. Let's just say this one. I think the pages were misfired. Maybe you have most requirements. 898. My lord, the point I was making before I was helping Mr. Sabganda is this: that this theory that the first respondent put in his answer and pursued in cross-examination, okay, was tending to show, the theory was to show that because of the patterns that he referred to, trajectories, guesswork, okay, he was saying that I would have won in those polling stations. But that's not where he stops, my lord. He's saying because of that he won in majority, I would have won in the 14, therefore the election would not be affected substantially. That's where he leads to. And my point, my lord, that I'm making with this decision is that that theorization is without legal basis and cannot be a reason for saying that the election would not be affected in a substantial manner. Let me also make this third point, my lord, again as I walk away from this issue. What is at stake, my lord, if we first put the rights and competing interests of the petitioner and the first respondent? Let's also think about the 16,640 voters who were disenfranchised. These people went to vote. We don't know how many went. We don't know how many turned up. But we know that people turned up to vote at these polling stations. But their results are nowhere to be seen, my lord. They are not in the tally sheet. They were disenfranchised. My lord, can we say, therefore, that their votes don't count? that their votes carry less weight, that their votes are irrelevant, my lord, their lordships